July 2020, 6 years after Officer Darren Wilson killed Michael Brown, St. Louis County Prosecutor Wesley Bell announced that his office had taken another long look at the case and decided not to file charges. But he was very careful to say the decision was because he didn't think prosecutors could prove guilt beyond a reasonable doubt with the evidence as it is. He was not exonerating the cop, but that didn't stop some people from taking it that way. He took a lot of heat for his decision, probably still is. But Wesley Bell's hands were tied, and they were tied by his predecessor, Robert McCulloch, whose office used a sham grand jury not just to clear Officer Wilson, but also to make sure he could never be prosecuted.
There are at least 3 things that prove the Michael Brown grand jury was a sham. 1. McCulloch blurred the lines between indicting grand juries, investigative grand juries, and trial juries, each of which, if you've seen part 1 on the Breonna Taylor grand jury, you already know have distinct roles in the justice system. And if you haven't seen it, first 5 minutes will help you understand this a little bit better. Indicting grand juries confirm prosecutors have probable cause for the charges they're seeking. Investigative grand juries investigate accusations that for whatever reason have not and cannot be investigated by law enforcement and indict those supported by probable cause. And criminal trial juries convict when prosecutors prove guilt beyond a reasonable doubt.
For reference, civil trial juries decide whether cases have been proven by a preponderance of the evidence, more likely than not to be true. So a grand jury's decision doesn't even mean something's more likely than not to be true, just that it could be true. McCulloch, on the other hand, called a 45-minute press conference where he said the grand jury proved Officer Wilson's version of the shooting. He made a big deal about grand jurors hearing from every witness and examining every piece of evidence, as if it were an investigative grand jury. But every witness had already been interviewed, many of them multiple times, every piece of evidence collected, and multiple autopsies performed. Grand jury wasn't investigating, prosecutors were presenting evidence.
Which is reason number 2 we know the grand jury was a sham. Instead of trying to indict Officer Wilson, prosecutors made his case for him. Dorian Johnson, Michael Brown's friend who was with him when it happened, was the key witness against Officer Wilson. So if prosecutors were trying to indict, then they would have done their best to protect his integrity as a witness for trial. Avoid him saying anything that defense attorneys could use to impeach him, which is to make a witness out to be a liar or otherwise undermine credibility. Which makes how prosecutors actually treated Dorian Johnson appalling. He appeared at 1 p.m. on a Wednesday, thinking he was there to help prosecutors indict Officer Wilson. He even started off thanking grand jurors for taking the time to hear his story.
What poor Dorian didn't know was that prosecutors had spent all morning playing hours of recorded statements he made, everything from police and FBI interviews to appearances on the news. Some of those statements were inconsistent, making him look like a liar, which no judge would allow at trial because you cannot impeach witnesses before they testify, because that would be unfair. Prosecutors didn't just impeach Dorian before testifying, they set him up to keep impeaching himself every time he said something that didn't match up with what grand jurors had heard earlier. In fact, they let him talk freely until he called Mike a good guy, at which point prosecutors interrupted to ask a series of questions referring to Michael Brown as brash, indignant, threatening, extremely intimidating, macho, and bold. That's how prosecutors describe the victim while discrediting the prosecution's most important witness.
Reason number 3 we know the Michael Brown grand jury was a sham. McCulloch released the transcripts without even being asked. Secrecy is the defining characteristic of the grand jury, and courts protect it vigorously. In fact, a Michael Brown grand juror has been suing since 2015 to respond to McCulloch's public statements, denied in both state and federal courts. Grand jury secrecy is so sacrosanct, even when it's already been broken, can't be allowed to break any further. Some defense lawyers go their whole careers demanding grand jury transcripts and never once getting them, because prosecutors are not required to hand them over, and disclosure only helps the defense, like it did here. Calling every witness, then disclosing the transcripts effectively ended any possibility of convicting Officer Wilson.
The Michael Brown shooting sparked the hands up, don't shoot movement, but the story it was based on, that he had his hands up to surrender when he was shot, wasn't just proven to be untrue by the autopsies. It was also not what a lot of witnesses said they saw when asked about it right after it happened. But saying anything that undermined the movement would have been perceived as helping Officer Wilson get away with it. So some witnesses said they'd go to jail before testifying to what they saw, and sure enough, they ignored grand jury subpoenas. Others appeared but changed their stories to match the movement. Michael Brown had his hands up. He was surrendering. 2 different stories, one to officers, another to the grand jury. A verifiable lie under oath. The transcripts alone are enough for Officer Wilson's defense attorneys to impeach many of the prosecution's key witnesses.
Which is why St. Louis County Prosecutor Wesley Bell should be commended for his integrity and not condemned for his decision not to file charges. As you'll see in Part 3, the Michael Brown story retold, there is easily enough evidence to indict Officer Wilson. Media would have dragged him, and it would have given Michael Brown's supporters some sense of justice. But a prosecutor could not prove guilt beyond a reasonable doubt with the evidence as it was left after the sham grand jury. And ethically, prosecutors should not charge people they cannot convict.
We hope you learned something about the Michael Brown grand jury. Please like and subscribe if you did.